our experience. Try to give you a brief introduction into changes into the definition of insolvency, which has been introduced by a very recent reform of insolvency law in Poland. Maybe to start with the background information on the reform. The reform was initiated in 2012. I took part in actually in both parts in the reform, so I had a direct experience with it. It was initiated in 2012 and was concluded with the adoption of the restructuring law in 2015. And in parallel, it brought very significant changes to the bankruptcy law from 2003. So it is still a bankruptcy law from 2003, but starting from 1st January 2016, it is in a completely changed shape. And actually, I will concentrate on this bankruptcy law from 2003. As it includes the definition of insolvency, which is also relevant for restructuring law. To have as an introduction, give as an introduction a kind of overview of Polish insolvency proceedings. This definition is relevant both to bankruptcy proceedings under the bankruptcy law, which are applicable to insolvent debtors. But it is also relevant for restructuring proceedings. We have different sets of restructuring proceedings. Differences between them are not very relevant for our topic, but the common factor is that those restructuring proceedings are applicable either to already insolvent debtors or can be also applied to debtors threatened by insolvency. And as regards the definition of insolvency, the restructuring law simply includes a reference to the bankruptcy law. So I would concentrate on this definition as provided for in bankruptcy law, in two key provisions, Article 10 and 11. Article 10 simply says that bankruptcy proceedings are opened against an insolvent debtor. So the definition is actually, the whole definition is actually included in Article 11. As probably most jurisdictions, we have two definitions of insolvency, and we had them also before the reform, cash flow insolvency and over-indebtedness. Logically, we have the cash flow insolvency is applicable to all debtors, while the over-indebtedness is the definition of insolvency which is applicable to legal persons, most obviously companies, and partnerships, except partnerships where at least one fully liable partner is a natural person. So that in practice means that this definition is applicable to limited partnerships where the fully liable person is a limited liability company or another company. As said, in restructuring proceedings, the definition, the provision refers to the definition of insolvency of the bankruptcy law, and it also adds the explanation what is debtors threatened by insolvency. The debtors threatened by insolvency is defined as a debtor whose economic situation suggests that he or she may become insolvent in a short time. I would move to the definitions of the insolvency, and I would like to underline the changes that were brought to both definitions under the previous reforms, under the recent reform, which were obviously kind of an answer to deficiencies of previous definition. Cash flow insolvency is defined currently as inability to perform monetary obligations as they become due. This wording departs from the previous wording, which was I have reproduced in the presentation, which said the debtor is considered insolvent if he or she does not perform his due monetary obligations. And we had a huge problem in practice under the previous law, under this definition, which the reasons for this problem are partly, I would say, even cultural in our court system. We have a kind of formalistic approach in many courts. So literal interpretation of law usually prevails over any functional or systemic interpretation. So most courts took this definition very literally, and the result was the so-called, in professional jargon, rule of two invoices. So it was, under the previous law, it was enough if a company, or if the debtor did not pay two invoices to consider him or her insolvent, even if those invoices were irrelevant and the debtor was a huge company, which from the economic point of view would be a obvious nonsense. Already under this previous wording, there were decisions of the Supreme Court rejecting this formalistic approach, this rule of two invoices, but those decisions were largely not followed by the court. So most courts stick to this literal interpretation. So in result, the wording has been changed to emphasize that it's not actually the fact of obligations not being performed, but the inability to perform those obligations constitutes cash flow insolvency. And a rebuttable presumption has been added, meaning that inability to perform monetary obligations is presumed if delay in performance exceeds 3 months. So it's a rebuttable presumption, so obviously actual insolvency may occur earlier, but may also occur later. But in the latter case, the debtor would need to demonstrate it, and the easiest way to demonstrate it is simply by paying those obligations. Commentators explain well, the cases where the presumption can be rebutted, that it should be done on the basis of short-term cash flow, analysis of short-term cash flow, and international auditing standards should be taken into account as an additional criterion. Obviously not a formal criterion, but it's useful for analysis whether the presumption can be rebutted in either direction. Okay. I would move now to the second form of insolvency under Polish law, the over-indebtedness. So this part of the definition which is usually causes more problems. Just as at the beginning, I would just make a remark that over-indebtedness has been greatly reduced in its practical role by this recent reform. So I would say there are sadly no statistics, but I would say that probably 90 or more % of cases of insolvency, of bankruptcy proceedings being opened, are opened on the basis of the cash flow definition, not on the definition of over-indebtedness, and even more so under current law after the reform entered into force in 2016. What is over-indebtedness according to Polish law, and what relation does it have to balance sheet of the debtor? I have to admit at this point that the second question would remain open, so there is no definite answer to the second question under Polish law. Anyway, starting from the range of application and from the definition, as said before, over-indebtedness is applicable to legal persons and those partnerships where there is no fully liable partner as being a natural person, which has intended consequence that all entities covered by this definition are also subject to full accounting requirements. So obviously that makes it easier for those entities to identify over-indebtedness. It is defined as a situation quite similarly to probably to other jurisdictions when monetary obligations of the debtor exceed the value of his or her estate, and that's a new addition under Polish law, and such state continues for more than 24 months. So that's this addition greatly reduced the role of this form of insolvency. Why those 24 months? The most obvious purpose is to avoid including temporary situations, to avoid hastily declaring a debtor insolvent when in a normal course of things, in many cases, a company would be temporarily in this situation. For example, startups that start activity financed by credit, some valuation changes of assets were resulting from changing market conditions, or it can be especially significant in companies with little tangible assets, so for example, companies in the service sector. The second purpose of including, making this period 24 months instead of, say, 12 months or 36 months is to include in any case a full accounting year. So in any case, 2 year-end balances have to be included, and that has a, I will come back to this issue in a moment in the next slide. That will be a, let's say, a ancillary criterion for the debtor to identify such situation. This, I would say, secondary role of over-indebtedness as a criterion for opening proceedings is emphasized even more by the rule provided in paragraph 6 of Article 11, saying that even in such case, so even if we have this over-indebtedness and it persists for more than 24 months, the court may refuse to open bankruptcy proceedings if there is no short-term threat of loss of the debtor's ability to perform monetary obligations as they become due. So basically, this presumption, so not presumption, this definition of over-indebtedness, its role is simply identifying those debtors who would anyway become insolvent in the cash flow meaning of the word in a short time frame. And if it is not the case, it is not binding for the court to open. It is not obligatory to open insolvency proceedings in this case. A few detailed rules. And I would try to, I would mention some controversies arising among commentators and also in practice as regards application of this definition of over-indebtedness, which have unfortunately not been solved, not all have been solved by the reform. First of all, this definition of indebtedness takes into account provisions of bankruptcy law providing for the scope of assets which will be which will cover the satisfaction of the debtor in proceedings. So first of all, assets which are excluded from the bankruptcy estate are not taken into account in the calculation. In case of companies, those assets excluded from the bankruptcy estate are some specific purpose funds for social purposes directed for the employees of the debtor. They remain the property of the debtor, but they are not included in the insolvency, in the bankruptcy estate, so they are also not taken into regard when assessing the over-indebtedness. Second, future obligations and obligations under suspended condition are not taken into account. Those obligations have not yet materialized, so they are not relevant for examining insolvency at a specific point in time. They may become relevant in the future once they materialize. Third limitation concerns shareholder claims. Similarly to German law, actually our regulation was quite based on the German law. Shareholder claims, which earlier were considered to be converted into an increase of share capital of the company in case of its insolvency, now have been requalified. They simply become subordinated in case of insolvency. They are satisfied in the very last rank in the distribution of proceeds from insolvency proceedings. If they are satisfied in the very last rank, they are actually the economic position of shareholders is not very, in regard of those claims, is not very much different from their position in regard of their shares in the company. In both cases, they usually get zero. So the decision was to exclude those claims from the assessment of liability side for the purpose of specifying, of examining whether the debtor is over-indebted. And finally, there is the most important question. What meaning, what is the, I would say, impact, significance of the balance sheet to the application of this definition of over-indebtedness? There is a presumption that over-indebtedness exists if liabilities of the debtor according to the balance sheet, except provisions for liabilities and liabilities towards linked entities, exceed the value of the assets of the debtor, and this state persists for more than 24 months. So the presumption points to balance sheet, but it is also in this case only a rebuttable presumption. What follows is that balance sheet values, balance sheet valuation, is significant for the application of over-indebtedness, but it is not binding for the analysis of indebtedness in the meaning of the bankruptcy law. Most commentators say now, and that's actually the point where the law stops and where interpretation starts. So most commentators consider that market value of the assets has to be taken into account in the meaning of sale price that can be reasonably expected when sold to an unrelated entity. And there are different opinions whether it means fair value, whether it means market value in conditions of a forced sale, or whether it means market value with under expectation of a continuing entity. And obviously, whichever of those valuations you take, it may have significant impact on the result. The result is, I would say, quite uncertain. So some voices say that balance sheet valuation should be taken into account, and it would be actually a better idea to link this definition of over-indebtedness to balance sheet valuation formally instead of taking it into account only as one of the criteria. The practical solution, the practical idea to companies who consider whether they are insolvent is simply to take the balance sheet test as a kind of introductory test, and if the balance sheet test points at balance sheet insolvency, so the liabilities exceed assets, obviously only liabilities and assets according to those exclusions that I have listed before, then it should be considered as a very serious warning signal, and then the company should do the same test, but using valuation according to the fair value or market value of the assets, and do it on a monthly basis, because then if the balance sheet test done twice year after year points towards insolvency, then in most cases the company would be indeed insolvent, but it has to be examined according to the market value under the law. Another issue regarding to the definition of over-indebtedness is the fact that non-monetary obligations are not taken into account. In the very definition, it is the term monetary obligations is used. The purpose of this exclusion is that current mutual contracts, which are during their execution, so they are they are being performed at the time, do not influence, do not lead to over-indebtedness. Okay, I would go to the last issue. Sorry. The last issue is the deadline for filing for bankruptcy. That's where this definition is most relevant for managers of the company, which are obviously liable for damages if they file too late or if they don't file. And in companies they are even liable. They even bear criminal liability. The deadline has been extended from 14 days under the previous provisions to 30 days from the moment insolvency arises, which may be not so significant, because with 14 days and 30 days, it's, the practical difference would be not so great. But the main difference results for combined application of the new deadline and this presumption applying to cash flow insolvency, which I have mentioned before, that delay in performance exceeding 3 months only triggers the presumption of cash flow insolvency. So obviously presumption is rebuttable, but in most cases the practice tends towards a kind of I would say practical approach that when a debtor stops paying, then the presumption kind of protects him for 3 months, and after those 3 months the 30 days deadline starts ticking. So the Polish insolvency practice tends towards a practical assumption that the actual deadline would be 4 months from the moment the debtor stopped paying his or her due obligations. And if some doubts arise in cases and litigation regarding liability for damages or litigation regarding sanctions against managers, then obviously it would need to be demonstrated, proven in either direction whether the presumption could be rebutted. So, and it also has can have a role when the fault of the managers is assessed, whether they were they could have relied on this presumption in a justified way. I think that would be all as regards this description of those new Polish rules. I hope it has been clear, and I hope it has well answered questions that also economists may have. I have to admit I am a lawyer, I am not an economist, and that was frankly a structural weakness of Polish insolvency reforms, that there was little dialogue between lawyers and economists. So law was written by lawyers. The economists took part in the team working on the reform, but unfortunately there are very little persons who have a very good grasp both of economic and of legal issues concerning bankruptcy, who could have been included in the drafting of the law. So those provisions still get a lot of criticism from economists, and on the other hand, the proposition of the economists have been, most of them have, during the drafting of the law, have been dismissed outright, mostly by judges, that they would be impossible to apply in a court proceeding. So it would be interesting for me to also to hear the Czech experience, whether those two perspectives were satisfactory, united in a satisfactory way in the drafting of the insolvency law. Thank you very much for your attention.